Good afternoon, everyone, and a very warm welcome to our webinar, Responsible Redundancy. I'm Sally Gwilliam, a partner in the employment team here at Harper James, and I'm joined by my colleague, Helen Dyke, who's a senior employment solicitor. Today, we're going to talk through responsible redundancy, so how getting redundancy right can protect your brand, enhance your employee culture, and ultimately come out of the process with a stronger and more resilient business. So we're looking at, firstly, legal essentials, so for a fair and compliant redundancy process, alternatives to redundancy that could help you actually retain talent, how to manage morale before, during and after redundancies, balancing cost-saving measures with long-term resilience, and protecting your reputation and employer brand throughout. So why are we looking at this? Well, results of a recent survey was undertaken by CIPD, were published in February this year, actually found that there was a significant fall in hiring confidence and an increase in redundancy intentions over the last quarter, perhaps not surprisingly. So it followed the rise in national insurance costs for employers and national minimum wage increases, which came into effect in April this year. According to the research, redundancy intentions have risen to their highest level in the last 10 years outside of the COVID-19 pandemic. Almost a third of those surveyed plan to reduce their headcount through redundancies or recruiting fewer workers, and a quarter report that they are cancelling or scaling down plans for investing in or expanding their business. Just looking quickly at another survey from Census-wide, unfortunately it makes equally pessimistic reading. There it shows that of those surveyed, 33% were looking to make job cuts, 46% are looking at price rises, and 35% are freezing hiring. I know we've certainly seen an increase at Harper James over the last 6 months or so in giving advice to employers on how to effect redundancies. We'll go on to see, though, that not all redundancies arise as a result of needing to cut costs. They may need to be a result of a restructure of teams and departments as a business grows, or new technology may be implemented, bringing about a change in roles. So if we just move on to the webinar now, so looking at protecting your business, how to balance, we need to take a balanced approach to tough decisions. So we'll be focused on protecting your business, so enabling long-term sustainability while navigating economic or strategic shifts. Supporting employee well-being is important, ensuring fairness and transparency and compassion throughout the process. Preserving reputation and morale, so maintaining trust with your remaining staff and external stakeholders, and strengthening future resilience, positioning your organisation to be able to rebuild and thrive post-restructure. Helen's first going to look at the legal essentials of a fair redundancy process.
So let's begin by going back to basics, defining what we mean by redundancy. And often when I'm advising clients, we'll just go right back to that question. What do we mean by redundancy? Now, under the legislation, an employee is dismissed by reason of redundancy if the dismissal is wholly or mainly attributable to one of these three key situations. So business closure, workplace closure, or reduction of workforce. And it's really important to remember that redundancy is about the role disappearing or changing. It's not about the individual or their performance, for example. So let's have a look at business closure firstly. So this is where the employer ceases or intends to cease the business in which the employee was employed. So we're looking here at a scenario in the example there where ABC Limited, they've lost their major client base. So all employees are at risk. So the company is either going into liquidation or it's winding down. And you can see that there in that example. And then the second option is workplace closure. So you've got an example there. Again, we're looking at ABC Limited. It's got an office in Bristol and Leeds. It's got dropping sales in the north. So there's a decision made to close the Leeds office. And this is the workplace closure scenario. So there's a specific site or a location or an office, and the business may continue to operate elsewhere, but this particular location is closing down. Now, a few quirks on this one then. So if employees have a mobility clause in their contract, then you could potentially require them to work at another location. But that is a bit of a complication. So you do need to think about it very carefully before you do that. Key questions would be, is it reasonable to enforce the clause? you're thinking around factors of distance, cost, personal circumstances. Here we've got Bristol and Leeds. It's not really very reasonable, but it's something to go through with employees in terms of consultation, but probably not reasonable to rely on that mobility clause if they have one. And then you're going back into that redundancy situation rather than relying on the contractual position. And then just thinking if ABC had 2 sites in Leeds and it's only closing 1, then that redundancy pool could be broader. You might need to just apply your minds to that. We're going to look at redundancy pools later on in the webinar. So you would need to think about the roles at the remaining site. Are they comparable? Is it fair to limit selection just to those at the closing site? And that's where you really need to demonstrate a fair and transparent selection process. It's really essential to making sure that you're minimizing risk and doing things properly. And then thirdly, you've got the perhaps the more classic example, a reduction in the workforce. So that applies where there's a need or a reduced need for employees to carry out work of a particular kind. So this might be thinking back to the examples that Sally gave you in the poll. So we might be thinking about restructuring. Maybe there's some use of AI or automation that means we've got less need for employees of a particular kind. Maybe you're looking at some outsourcing, or maybe it's just simply falling demand, need to save costs as an example. So looking at the example there, then we've got the employer deciding to make better use of resources. The MD is absorbing the duties of the general manager, so we just don't need that role. And then also we've got a customer reducing the amount of its orders, so there's fewer production staff needed. So classic examples there on that third scenario. And we're not going to focus on this today, but I did want to just touch on collective consultation. So this is where an employer is proposing to make 20, that's the magic number, so 20 or more redundancies at one establishment within a 90-day period, and then that's when collective consultation requirements are triggered. So if you're looking at 20 to 99 redundancies proposed, then you've got some strict requirements to comply with, including that, most importantly, that consultation has to start at least 30 days before that first dismissal can take effect. And if the proposal involves 100 or more redundancies, then you're looking at a minimum consultation period of 45 days. Now, during this process, you have to consult with appropriate representatives. So that could be trade union reps if you recognise a trade union, or it could be elected employee representatives. And you also have to notify the Secretary of State using a specific form, HR1. Now, if you don't do this, if you fail to comply with the requirements around collective consultation, it can result in a very costly protective award claim of up to 90 days pay per affected employee. So the stakes are really high on it. You do need to get it right. And just to flag really that you ought to be thinking about, if you haven't done it before, maybe taking some advice on it so that you fully understand and make sure that you're complying with all the legal requirements. Now, when making redundancies, obviously one of the goals is that we want to minimise the risk of a claim for unfair dismissal. And you'll do that by making sure that you show that the redundancy is the genuine reason for the dismissal and that you've acted reasonably throughout, you've carried out a fair process. So that involves obviously the process itself. Is it fair? Is it transparent? Are you fully engaging in meaningful consultation? Now, a common pitfall that we see is, particularly when you're trying to save costs, is rushing into consultation without doing that proper groundwork first. So the planning stage is absolutely critical. Before you start any conversations with staff, just make sure that you're really clear on your business case and what you're hoping to achieve. Get it written down. So that's part of your evidence, that you know what the rationale is, and that you're able to clearly explain what's driving these proposed redundancies. So that, as we've said, it might be cost saving, it might be restructuring, it might be a drop in demand, but we need to be really clear and to be able to be in a position to communicate that to employees so that they get what you're doing, they understand. Now, we've talked a lot about consultation. So what is it? Well, fair consultation means more than just informing employees of a decision. You really have to look at making sure that they've got a genuine opportunity to fully understand what you're proposing, that they can really share their views, and that you're properly considering those views before you're making any final decisions. You've got a rather old case there, the British Coal Corporation case, which sets it all out, and that's what we refer back to. But essentially what it means is that you don't have to agree with or adopt those views of the employees, but as the employer, you have to be able to engage genuinely and openly in that process and make sure that the employees understand and that they don't feel rushed. So a fair consultation process, at least in my view, this is what I go back to when I'm advising clients through a process. So that it rests on these three key points that you should be bearing in mind. So firstly, are we clearly informing employees about what's being proposed and why? And that's not just a verbal discussion, it goes beyond that. Obviously, to talk to them in the consultation meetings about it is really important. But then we need that documented, that to be reflected in the letters that we're sending out, so that we can evidence that we've properly informed them and explained the proposal. And then, as we said, engaging meaningfully, that is so important. Really listening to their feedback, fully, properly considering alternatives, and answering questions as openly as you possibly can. And it's just really, really important not to rush this consultation process. In theory, it could be a couple of meetings done in, 3 or 4 days. That's just really not going to be good enough unless, well, in very rare circumstances, you really ought to be looking at, I normally say, sort of 2 to 3 weeks and sufficient meetings until you've exhausted all questions from the employee. And then throughout, obviously, be sensitive. Redundancy, it's highly personal. It's very stressful for the people involved. And we need to be handling these conversations with empathy and respect and care, and thinking about, morale of employees who are involved. And that will then help to reduce your risk around this process. So a critical point to think about right at the outset is pooling. So the pool is the group of employees from which you're choosing who might be made redundant. Now, there's no fixed legal rules on how to define the pool. You do have flexibility as the employer. But what matters is that the approach is reasonable and that you can show that it's based on objective criteria. Now, an employment tribunal, it's not going to second guess the choice of the pool, as long as you can show that you've taken a logical and fair approach. That's really important, that you've thought about it, that you've documented your reasoning. And it might be the case that employees ask questions, challenge the pool, want to make it broader, and you need to show that you're engaging in those questions and really, really thinking about it. Now, when deciding on the pool, you start by looking at what the employees actually do on a day-to-day basis. So we're not just thinking about the job titles, we're thinking about the actual work that's ceasing or reducing, who carries it out. We're thinking about whether others do similar or interchangeable work. And, sometimes a pool of one can be fair. So you've got the case of Wrexham Golf Club and Ingham. Mr. Ingham, he was the only golf steward at the club, and his role was made redundant. You might think, well, that's a pretty easy case, pretty obvious, but it went all the way up to the Employment Appeal Tribunal, so it must have been a pretty expensive case for the golf club. And Mr. Ingham was arguing that the club should have included other people in the selection pool around things like similar or interchangeable skill sets. Now, the EAT, the Appeal Tribunal, found in this case that a pool of one was fair, and they said that no one else did the same or similar work, but it's always fact specific, so you do need to be really careful when you're thinking about pools. But it does confirm, when you have roles that are truly unique, limiting the pool to one can be reasonable. but we go back to the fact that that has to be a decision that's made based on sound logic, and that you're not using it to target somebody unfairly. And that's often the allegation that you'll get back from the employee. Well, why me? What about this person over here? And on that note, you might also get employees alleging or asking for you to consider bumping. So bumping, it's a bit of an odd one. It's quite uncomfortable to think about it, but it's where you've got a more senior employee at risk of redundancy, and they're saying that they should take the role of a less senior employee, so literally bumping them, to avoid redundancy themselves. So you can imagine it's difficult conversation to be had all round. But as confirmed in the case of Samuels and University of Creative Arts, you're not legally required to offer bumping. It's something that you need to think about. That's often a challenge raised by employees, but for obvious reasons, it can be pretty damaging to employee relations. So you need to be thinking about it very carefully, whether it's appropriate, and being able to justify your decision on this and in each situation. So moving on from pooling then, the next key point to think about is selection criteria, which Sally's going to cover for you.
Thanks, Helen. So Helen's explained how you might want to pool roles. So I'm going to look at how you would select them from these pools. So those who remain in the pool and those who actually get the job successfully. So to do this, you need to score each individual in the pool against different selection criteria. Now, the criteria, as it says there, should be objective and capable of independent verification. And by this, I mean criteria should not be based on personal opinions or favouritisms. And it's really important that a third party could look at how the employees are scored, be able to understand it, and be able to kind of verify this. So some examples of objective selection criteria includes things like disciplinary records, attendance records, performance and ability. So you might look at scorings on past appraisals, which is always quite helpful. And it is also fair, if you wanted to attach greater weight to some criteria compared to the others, provided you can explain why you've done that and justify it. Of course, you need to apply all these selection criteria fairly to everyone. So actually, you might consider making some allowances for individuals in the pool who have protected characteristics. So, for example, we talked about attendance records. We might want to make some adjustments there if you have some disabled employees, for example, who are on long-term sickness absence, or you have employees who are on maternity leave, so haven't been there for that period. And similarly, things like performance records for those on maternity leave, for example, you might need to adjust their targets, make adjustments for those on leave because they haven't been there to perform in the same way. Looking at kind of last in, first out, so LIFO, that used to be quite a common selection criteria that we used, but we don't generally use it anymore because it could be deemed to be kind of discriminatory on the grounds of age. What we might use that for is if there's a tiebreaker, so if there's a tied score, so you might use that to decide actually who gets the higher score or not. As part of the consultation process, employees should absolutely be consulted about the criteria and about their scores as well. So looking at the next slide, where an employee remains at risk of redundancy, it certainly would likely to be an unfair redundancy if there's been no consideration for suitable alternative employment. So we're going to look at that now. And what do we mean by considering suitable alternative employment? Well, we mean you need to carry out a search for other vacancies within the business. And case law has shown that employees do need to be quite proactive here and need to provide employees with sufficient information about vacancies so that the employees are able to make an informed view as to whether that position is suitable for them or not. I'd always advise giving a kind of list of vacancies in the company with some clear contact points within the business for that individual to get more information, and really not make any assumptions either about what roles the individual may or may not be interested in. As it says there, though, there's no obligation to actually create a new role, and you should absolutely be sharing all this information in the consultation meetings. So as I said before, it's a good start to provide a job list, but then you should also assist that employee in their search as far as you can, and then you can't be criticised for not exploring all alternative employment. So looking at who you might get that role, so If there's more than one person who expresses an interest in a suitable alternative role, then how would you select who gets it if there's more than one person at risk? So you might consider options including making them do an application for the role. You might do selection criteria as discussed before in relation to the actual pooling, or you could ask them to go through a competitive interview. But it should be explained to the employees how you're proposing to select for that role and have a discussion with them as part of the consultation process. So if a suitable alternative role is found, that of course avoids redundancy, but what happens if actually the employee decides they don't want that role? So the repercussions of this really depends on whether the new role offered was a suitable alternative role or just an alternative role. So in summary, if a suitable alternative role was offered, so by that I mean a role that was suitable in terms of the actual type of the role, the pay, the benefits, the seniority, the line management. So if that sort of role was offered, but then it was unreasonably rejected by the employee, well, the employee would still be treated as being made redundant, but they would actually lose their rights to a statutory redundancy pay. Looking at trial periods, so where notice has been given, but then alternative employment is being offered on different terms, it's subject to a statutory 4-week trial period. And really the purpose of that trial period is both for the employer and the employee to assess the suitability of the alternative employment. And either party during that time can decide actually to resign or to terminate their employment. And in which case, if they did so, they'd still be treated as being made redundant. But as I've just explained, if actually that role offered was suitable alternative employment, then the employer would actually lose their rights to a statutory redundancy pay. So just going back to kind of consultation, how long we think that should actually take. I know Helen touched on this, but the short answer is really actually it depends, which is perhaps a bit unhelpful, but it depends on things like actually how many employees you've got involved in the process, whether there actually is a need for pooling and selection, because it might just be it's one individual, which will obviously be a much more shorter and straightforward process. We'd need to look at things like actually the availability of people for the meetings and whether people are absent or not. And of course, the amount of queries and issues that are raised in the process. The consultation absolutely needs to be meaningful, means it needs to be a process. You take on board the individual's feedback, proposals and their comments. So I say that actually as a rule of thumb, you need at least 3 meetings. So the first meeting would be to actually announce the proposed redundancy, so put the individuals at risk of redundancy, not achieving very much in that meeting, just to simply to do that. And then you would normally have a first formal consultation meeting individually with each employee. And there, as we discussed before, so you respond to their queries, you take on board their proposals and any comments they have. And then you might actually have a kind of second meeting, or it might be the final meeting, and actually where the decision to dismiss can be made. Likely, if there is a need for selection and pooling, then there probably would be at least an extra meeting, because you need to do things like discuss the selection criteria, the scoring, and the outcome of the scoring. And just remember that we're just talking about here individual consultation. As Helen explained earlier, the process and the timing is very different where you're proposing to dismiss 20 or more employees, where you've got to consult collectively. So just touching on absent employees, we're looking at a few tricky issues here. So do we need to consult with them? Well, yes, absolutely. You do need to consult with those people that are on long-term absence, for example, those on maternity leave or other family-friendly leave or on long-term sickness absence. If you don't do so, then it's highly likely that that would be an act of discrimination against them. Ideally, face-to-face meetings are best, but that might not always be possible. And certainly for those with a disability on long-term sickness absence, for example, you might consider if reasonable adjustments need to be made to enable that kind of meaningful consultation. So, for example, you might allow a family member to accompany them, or you might have meetings in a neutral location, or you might even do the process in writing if you have to. So looking at maternity leave, which is another kind of tricky area, and actually it's one of the few areas, mainly the only area, which permits actually positive discrimination. So the law here is where an employee is on maternity leave or they're in a protected period, the employee is entitled to be offered a suitable alternative vacancy where there is one, and they actually take priority over other employees who are at risk. So it's those on maternity leave and also in the protected period. So since April last year, the protected period starts when an employee tells their employer that they're pregnant and ends 18 months from the date their baby is born. And if you don't comply with that, then any dismissal will be automatically unfair. It's really quite a complicated, nuanced area of law, though, and would always kind of recommend you do take legal advice in this area, as it can be quite costly if you get it wrong, both in relation to the protected employee and also in relation to the employees that hasn't had that protection, hasn't had that favouritism. So if we just look at redundancy pay now as well. So employees who have over 2 years service have a right to a statutory redundancy payment. They may well have a right to an enhanced redundancy payment as well. So we'll just check kind of contracts and policies just to ensure or see if there is actually any enhanced redundancy payment owed, particularly if you're a business that's recently acquired a business and TUPE has occurred, so they've transferred into your business. So kind of their terms and conditions they transferred on from their previous employer would transfer to your business. So any provisions, implied or express terms and provisions relating to enhanced redundancy payments would transfer over as well. So you would have to be paying these enhanced redundancy payments. Looking at the redundancy pay itself in terms of how that's calculated, I mean, it's quite an overly complicated formula in my view. The best way to work it out really is to go to the Government Redundancy Calculator website, and we'll put a link on this in the follow-up email that we'll be sending to all attendees after this webinar. But in essence, it's based on the employee's length of service, which was then capped at 20 years, based on a week's pay, which is capped at £719 now, and then it's multiplied by an age multiplier, as you can see there. So for every year of service where the employee is under 22, it's multiplied by half. For every year of service between 22 and 40, it just remains at 1. But for those years worked, 41 and over, there's a multiplier of 1.5. Okay, I'm just going to that's all the legal essentials now. So I'm going to pass you over to Helen to talk about alternatives to redundancy.
So yeah, the legal essentials, obviously critical that we get that right, and we've got the rules in place for a reason to make sure we're doing a proper and fair process, which is incredibly important when you're thinking about taking employees through that consultation process. But just to focus in on alternatives then, and this is something that you should do right at the start when you're looking at your business rationale and your proposal. I mean, you could almost use this as a checklist, and then it will be something that you explore with employees. So they will be coming up with their proposals, their challenges, their questions. So really important that you're thinking about alternatives and that you can document that you've fully explored all possible alternatives to redundancy, and you've really tried very hard to retain employees wherever you possibly can. So firstly, thinking about reducing hours, possible job sharing, anything like that that could potentially lower payroll costs whilst keeping people in jobs. And then secondly, temporary measures like short time working, temporary layoff, thinking about sabbaticals, that can potentially give you some breathing space during a downturn. And it avoids making those permanent job losses. So temporary measures, short time working, temporary layoff, sabbaticals, that could be something that you look at. And then thirdly, thinking about employees, whether or not they might agree to a voluntary pay reduction. Obviously, it's not something that people want to do, but if it means that they can stay in a job, then that is a possibility. Perhaps on a temporary basis, or perhaps looking at some unpaid leave, just to give you that breathing space. And if you're communicating with staff in a transparent way and you're reassuring them about the plan for recovery, then that might be something that you can look at to avoid redundancy. And then finally, thinking about really investing in reskilling staff or upskilling staff. So you're not only retaining talent, but you're also helping to redeploy employees into new roles. Is that a possibility? Have you really put your mind to that to see if you can support the business's longer term needs? And these options, obviously, the whole purpose is to see if you can avoid redundancy. It's really critical that you do that to minimise legal risk but also thinking about morale of the business. What are you doing to try and preserve that morale? And also thinking about your workforce's capability and maintaining that. Now, other effective alternatives, just to continue the list of ideas, that could include suspending or restricting recruitment. That's obviously something that employers will do right at the outset. Is there a way that we can stop recruiting, suspending recruiting, put that on pause for now? Because it doesn't look great, does it? I mean, there might be very good business reasons, but if you are recruiting in other areas of the business whilst making redundancies, you are going to, it's possible to do this, but you are going to have to think carefully as to how you justify that. But anything to help control headcount without affecting current staff, again, is going to stand you in good stead. Employers can also choose not to renew contractor agreements. So what contractors have you got on the books that you're working with? Can we look to reduce agency worker use? What other alternatives are there to cutting costs other than going to compulsory redundancies? And then thinking about voluntary early retirement, that could appeal to some employees, but I would be wary around that, particularly thinking about allegations of age discrimination. So just be a little bit careful with that. But restricting overtime, that is a very obvious one as well. Again, if you've got a big group of employees working overtime, but you're still making redundancies, then that is something that you need to think about how you justify that, because that is an obvious way to reduce costs. And then thinking about redeployment and really turning your head to it. It might be that an employee is actually doing one particular type of role, but they're really interested in doing another type. Have you fully talked to employees about all possible areas for redeployment, any vacancies that you've got, or looking at moving employees into other roles within the organisation? And how can you look to preserve those jobs and retain those skills? So just to focus in on voluntary redundancy, because we do get a lot of questions around this. Now, you're not legally required to ask for volunteers before you go ahead and make compulsory redundancies, but it can be a really good way of allowing people to, or inviting applications, and then you're then obviously, if you accept any of those applications, then it's helping you to reduce the number of compulsory dismissals. And it might be that you've got some people there that actually would, put their hand up to consider voluntary redundancy. You don't have to accept all applications, of course, so you're not losing people that you don't want to lose, but it is a way to reduce those numbers. And to encourage volunteers, companies will often offer enhanced redundancy pay in addition to the statutory minimum. Now, in some cases, you might also see settlement agreements being used, and obviously that gives you the ultimate protection. It secures that clean break, obviously manages legal risk, and it avoids disputes, but then you have got additional costs and time spent in dealing with those settlement agreements. But something to think about might be something that goes hand in hand with voluntary redundancy, potentially. Don't necessarily need it. And one thing I really wanted to focus in on is obviously managing morale. Now, it's hard, isn't it? Even if you're not affected, if you're not at risk of redundancy, the morale of the business is going to likely be hit by this process that you're undertaking. So it's really crucial when you're facing redundancies that you're thinking about morale. And I can't emphasize enough that one way to do that is really good communication and transparency, and employees should be kept informed in an honest and regular way, so that they're not feeling uncertain. They understand what you're doing, they understand the process, they're not just listening to rumours and they're worried about what's happening. So really important in terms of communication. And secondly, it's really critical to obviously show empathy and respect. Redundancies are really personal and they do affect people's lives. This when you're dealing with it. So just think about putting yourself in the other person's shoes, what they're going through, and being sympathetic to that. And then involving managers early, it's very important. You need them on board. You need them to be delivering the message in a sensitive and supportive way. It might be that their teams are at risk, or it might be that their teams aren't at risk. Either way, they need to be working with their employees, listening to them and reporting back issues. And that all helps to maintain trust and engagement, even if it's a really, really difficult time for your company. And you may also want to think about support services. So that often goes down really well. So how are we helping people to find alternative work if we have to go to redundancy? So sometimes companies offer counselling. More commonly, you'll see an outplacement service being offered, or career advice, and that that can help employees that perhaps need to really have a change of role, and they just don't know what to do. They might need help or support in preparing a CV. They might just not have an idea as to what to do next, so it just gives them that support and reassurance. And it's really important to think about the concerns of remaining staff, as we've said. So staff that aren't affected, they're going to potentially feel quite anxious, overlooked, worried about their own job security, and their own increased workload, perhaps if they're losing colleagues. So you do need to listen to them. It's really important, again, with the managers, that they're supporting their teams and that we're proactively addressing employees' worries openly. And then that focus on rebuilding trust and engagement. It's so important that you're involving staff in thinking about your future plans, that you're engaging with them, perhaps through surveys, through town halls, through regular meetings, managers having one-to-ones and check-ins with staff. It's so important to demonstrate that you're committed to them and to their well-being, and that's going to help you move forward more quickly after what can be quite a difficult redundancy process. And then when managing redundancies, it's really vital to think about balancing cost saving, which you might need to do immediately, but then thinking about your organisation's strategic priorities. So how are we going to prioritise retaining and looking after those key strategic roles, those people that are expected to drive future growth and success? So it might be that those people aren't at risk of redundancy, but how are we going to look after them and retain them when you're going through a redundancy process? So really important that you give that some thought, and then do your best, obviously, to make short-term cuts that might save money now, but ultimately could undermine your long-term capacity and competitiveness. And instead, you've got to be focusing on investing in your key talent as much as you can. Obviously, it's difficult if you've got a need for cost saving, but to ensure that your business remains resilient and ready to recover, obviously you've got to look after that key talent. And then just finally thinking about reputation and employer brand. Now, I can understand that you might not want to be advertising the fact that you're making redundancies. It has a big impact on your staff, on your customer base. If it gets out into the wider market, obviously it's not great PR wise, but the truth of the matter is, as Sally says, we are dealing with people, with companies making redundancies constantly at the moment. So you're not on your own, and you've seen the statistics earlier on in the poll that other people are going through at the same time. So, trying to hide these processes, it can often lead to inadvertent trust issues and low morale and a real impact on reputation. So I would ask you to think about, obviously handling the process with fairness and transparency. We've talked a lot about being transparent with staff, but also thinking about what message you're sending out to the market, to your customers. Do you need to be informing customers and the wider market? Does there need to be a press statement, for example? Is that something that you need to do? And open communication, consistent communication with staff is really, really critical. And then thinking about how you're treating people, so making sure that you're treating everyone with dignity and respect. You can actually get to a point where at the end of the consultation process, people feel that they're leaving the business and they've actually been supported and felt valued for what they've done for the business. So that's the ultimate goal, if you can get that. And I've had clients that have been quite emotional at the end with their staff at the end of a consultation process, and the employees have, you know, shaken their hands and said and thanked them for being honest with them, and that they appreciate that it's a difficult circumstance for the business. So that is the ultimate goal to aim for. And this, you do that through thinking about the support for affected employees and how you're guiding them. And, you know, we've talked about outplacement services and emotional support. Is there a, you know, a particular manager that they can go to for particular support throughout the consultation process, for example? And also, finally, most importantly, that internal and external trust. What are we doing to look after stakeholders, to look after our customers, to keep the wider market informed as appropriate? Obviously, you need to think about the messaging, because, you know, leaks out are not helpful. So if you're proactive about it, then that can sometimes nip rumours in the bud. So some things to think about there around morale, reputation, employer brand. It's a really difficult thing to go through, and you know, managers feel quite stressed themselves going through it. So do also think about the support for managers that are having to conduct these meetings and you know, take staff through the consultation process. So I'll hand back to Sally now for some final thoughts, and then we'll have some time for Q&A.
Great, thank you, Helen. So yeah, just the kind of 5 takeaways we've just kind of touched on. So really know the legal essentials. It's really vital to follow that fair and transparent process with proper consultation, selection criteria, notice periods, and redundancy payments to make sure you stay compliant. As we said, explore, number 2, kind of explore alternatives first, consider redeployment, flexible working, or voluntary exits before turning to compulsory redundancies. Prioritise communication and care, so maintain morale by being honest and empathetic and supportive at every stage of the process, and trying to think beyond immediate cuts, so aligning cost-saving actions with long-term talent, capability and business strategy. And as Helen has kind of spoken about before, about protecting your brand and culture, and how you handle redundancies does affect your reputation with your current staff, leavers and future talent. That's great. So we're now going to answer some questions that we received. We've got a few in the question panel, but if you still want to submit any questions, you can do so just in the control panel at the top. You can't see them, but the first question is, we have 2 employees on maternity leave. It's likely that both their roles will be made redundant, but there's only one suitable alternative role for them. So how do we go about choosing who gets the role, given they're both protected and should take priority for the role? Okay, it's quite a tricky question. There's no set kind of law around this about how you would go about doing this. So it's one that I would really hope the tribunal would allow an employer to take quite a pragmatic approach to this. There'd certainly need to be a fair process to decide which employee will get the role. And you'd probably suggest some sort of selection process similar to what we've spoken about previously. You could probably actually ask the employees, either of the employees, whether they want to take voluntary redundancy before you go through any sort of selection process, because that might just resolve the situation itself. But either way, however it's done, you must remain, I guess, open and engaged, explain to the employees how you're proposing to choose between them and address any concerns that they may have. Okay, I think there's another one, Helen, if you want to pick that one up.
Yeah. Oh, actually, yeah. Do we, good question, do we have to give employees the right to appeal against their selection for redundancy? Yeah, I was having this debate with a client the other day, actually. So it's not strictly a legal requirement. You might think it is, but it's not. So it's a bit different to going through a disciplinary process, for example, where obviously you'd need that right of appeal. It is best practice to do so, though, and I would urge you to include the right of appeal. ACAS, the non-statutory guidance, recommends it. And you know, if you're thinking about your selection process for redundancy, making sure that it's in accordance with a fair process, it's not necessarily going to be fatal to your defence if you get a tribunal claim, but it's a factor, isn't it, to be considered when you're looking at fairness. So even though obviously you've gone through the whole consultation process, you've met with the employees during that consultation process. It just giving them that chance to appeal, it just gives them that other opportunity to raise any additional queries, and from my perspective, for you to flush out any risk of a claim. So appeals, I think there's case law, isn't there, around appeals that they can remedy defects as well. So if you've got a defect in the redundancy consultation process, for example, if an employee thinks that they haven't been given enough information during a consultation process, maybe about selection criteria or scoring, then you could in theory remedy that at appeal. So yeah, I would urge people to use appeals, even though strictly speaking it's not a legal requirement. I do think it's really a really important part of the process. And just remember that if you are going to do it, that you have an independent manager to run that process that's not been involved in the redundancy consultation process at all. And obviously they should be accompanied as well by a colleague or a trade union rep, as you would do normally for appeals. So yeah, I think they're good to do, and it just gives that second stage of ability to challenge. But I appreciate its time and resources for you as well.
Okay, we've got another question in the questions. It says, should a company consult with employees prior to looking at alternatives to redundancy and understanding what every employee does? Or can this happen behind the scenes without employees knowing and consultation follows? So you're only under an obligation to consult with employees once you're at the stage of proposing to dismiss for a reason related to redundancy. So you may, I guess, look at kind of alternatives to redundancy before you start the consultation with the employees. Things like you might explore the ability to short-term work with people, or all those other kind of alternatives that Helen touched on. And I think that would then form part of your business case. So as part of your business case, you explain why you're proposing. And as part of that, I'd put in it kind of what other things you've looked at and explored before coming to the decision where you might have to propose the redundancies. And then that can form part of the individual consultation once you move on. Okay.
I've got another one actually that's just come in. If using any of the scoring criteria will not be objective or due to lack of record not being accurate, can the option to apply for a newly created position or role and attend an interview, would that be the most appropriate thing to do? It's a good question. We often get this, don't we, in terms of performance reviews, that you've not got records of appraisals or anything like that. So in terms of being objective, it's very difficult to have that evidence to prove. My view is that competitive interviews generally are best used for brand new roles, for new roles. So then you've got a group of employees that would apply for the role, go through a competitive interview process and prove that they're able to do the role. And you do that because you haven't got the evidence to back you up on whether or not they're capable of doing that role. But in this scenario, if you're concerned around scoring criteria, then yes, perhaps you could use an interview process to do that. But if you're reducing numbers down in a group of employees that carry out the same role, so maybe going from a team of, 5 sales assistants down to 3 sales assistants, it would normally be appropriate to use objective scoring for that. So you might struggle with using an interview for that, but overall it's all around the fairness of the process and making sure that employees understand what you're doing and why. So you'd have to put that thought into it. Good question.
Okay, we've got a few more. There's one here that says, if you have potential redundancies at more than one site, but at levels that don't reach the need for collective consultation, how open should you be with at-risk employees about the extent of redundancies across the business as a whole? I think you would certainly need at levels you don't even how open you should be. We should be, it's really up to you how open you want to be. Quite often these sorts of things, there will be, if you're speaking and putting people at risk of redundancy, it's very quick how that will kind of spread between the rest of the site. So it's probably better to actually consult with the employees, but also have a statement to go out to the wider business, just so you're ahead of the game there. In terms of if there are, I don't know if that's what we're asking, but in terms of if there are kind of the vacancies within other sites and it's all part of the same business, you should absolutely be putting those vacancies forward to employees that are at risk at the other site. Okay, have we got time for any more?
I can take one more if you like, Sally.
Okay, go for it.
So I don't think you've done the UK roles being moved to India yet.
No.
So going through, one of the attendees is going through a process of 6 redundancies at the moment. Essentially, it's UK roles being moved to India. These are all individual roles with individual expertise. How would you go about proving a pool, and would you need selection criteria? Well, the roles are just going in the UK, aren't they, but being transferred to India. So I don't think you would need selection criteria if all 6 roles are going. I think you'd need to talk to them about redeployment to potentially India. So you might need to think about that in terms of, within the company, presumably it's within the company, that there is an alternative role there. And if it's not within the actual company that they're employed by, it'd be within a group company. So you ought to be thinking about talking to them about vacancies within the group. But presuming that they don't want to relocate to India, then I think you'd be able to just go through with the consultation process about the actual move to India. It doesn't sound like you're looking at reducing numbers, and that would trigger the need for selection criteria. So you should be able to avoid that. It's all about the change to the business and the move to India.
Okay, great. So I think that probably concludes our kind of Q&A. We've come to the end of today's webinar. Very conscious that we've covered a lot of ground today, but we've only really scratched the surface in the short time we've had available. So there is more in-depth availability, more guidance available in the Knowledge Hub section of our website. We'll be sending links to all of you with the relevant information early next week, which will include a recording of the webinar and our contact details at Harper James should you need any immediate legal support. And also, if there are any questions that we haven't been able to get to, then we will look to respond to those as well. You can also watch our previous webinars addressing common business challenges on our website under our News and Insights section. So on behalf of Helen and myself, thank you for joining us today and enjoy the rest of your day.